All right, I think let's go ahead and get started. I'm Steve Wormiel. I'm a professor at American University, Washington College of Law, where I teach constitutional law, and have organized a preview like this one every year now for more than 20 years. And it's a great pleasure to do this with the Washington College of Law and the American Bar Association Division for Public Education. And thanks to the law school's Office of Special Events and Continuing Legal Education for logistics and nuts and bolts and so on. So we're going to have first a couple of welcomes. It's my pleasure to introduce the Dean of the Washington College of Law, Roger Fairfax, who became Dean in July 2021. He is a longtime renowned teacher and scholar in the criminal justice field, and has also been a leader in promoting diversity and inclusion in legal education and in the profession. Wonderfully accomplished individual, and it's an honor to have you give us a welcome. Thank you.
Well, good afternoon, and thank you, Steve, for that wonderful introduction. And on behalf of the American University Washington College of Law, I'm honored to welcome you to On the Docket, looking ahead at the new Supreme Court term, which is part of our celebration of Constitution Day here at WCL. And I wanted to bring greetings to our panelists, Roman Martinez and Kimberly Robinson and Erwin Chemerinsky, who I often call the Dean of Deans. So it's great to see you, Erwin. And in my opinion, one of my WCL faculty colleagues is the faculty director of our outstanding health law and policy program. And here at WCL, our motto is champion what matters. And we're thrilled to have such distinguished panelists for this critical discussion of the Supreme Court's work and its docket. And before I close, I want to convey my sincere gratitude to the organizers of today's event, especially the ABA Division for Public Education, of course, the WCL Program on Law and Government, which is led by our able moderator, Professor Steve Wormiel, and our AV and our event staff. And I also want to thank ABA President Deborah Enix Ross. Although she couldn't be with us today, I understand she's generously recorded a welcome message to kick off today's discussion. So thank you all for being with us today for this important discussion. Take care.
Steve, I think you're on mute.
Sorry. Thank you, Roger. We appreciate the welcome. Deborah Enix Ross became president of the ABA in August. She is a senior advisor to the International Dispute Resolution Practice Group at Debevoise and Plimpton in New York. And unfortunately, she couldn't be with us for the Zoom meeting today, but she did record a welcome, which we can hopefully listen to now.
Hello, I'm Deborah Enix Ross, President of the American Bar Association. Thank you for attending this discussion on the upcoming term of the U.S. Supreme Court. We very much appreciate the long-time collaboration of the ABA Division for Public Education with American University's Washington College of Law and Professor Steve Wormiel on this annual program, along with the involvement of our outstanding panelists. As a member-driven organization, the American Bar Association could not serve our profession and promote education about the law without your support of events like this. We help lawyers from all practice areas develop new skills and insights, understand their ethical responsibilities, and stay current with the latest developments. We emphasize the critical need for an independent, fair, and impartial judiciary. We advocate for legal aid and promote pro bono to meet the extraordinary legal needs of the most vulnerable in our communities. We work to eliminate bias and enhance diversity in our profession and justice system. And we demonstrate how the rule of law works and why the rule of law is so precious and so critical to our rights and our freedoms. The ABA's national voice for the legal profession is heard across the country and in our nation's capital as we work to educate Congress and the administration on issues of concern to all lawyers, including federal judicial nominations and protection of the attorney-client privilege. The ABA needs the support and participation of all lawyers so we can benefit from diverse perspectives and demonstrate that despite our differences, we are united as a profession. If you are an ABA member, I thank you for your support. If you're not an ABA member, I encourage you to visit ambar.org/each1ABA and consider joining us. That's ambar.org/each1ABA. Thank you for being here. I hope to see you at future ABA events.
Thank you for that welcome, and thanks to our tech people for getting the video going in the right place and right time. I want to introduce our panelists and then briefly lay out our plan for the program. I'm doing this in alphabetical order. Erwin Chemerinsky is the Dean of the University of California Law School at Berkeley, and a renowned scholar, teacher, and commentator in constitutional law and many other fields that are too numerous to name. Maya Mannion is my colleague here, a professor at the Washington College of Law and faculty director of our Health Law and Policy program, and her expertise in reproductive rights and other health law fields, among other subjects, will come in handy for our panel discussion today. Roman Martinez is a leader of the appellate practice at Latham & Watkins and deputy managing partner of the DC office. He has argued nearly a dozen cases in the Supreme Court, both for the United States in the Solicitor General's office and for private clients at Latham. And Kimberly Robinson is a longtime reporter for Bloomberg Law, where she has covered the Supreme Court for more than a decade. She's a former Big Law associate at Morrison and Foerster, so she's seen the things we're talking about from two different angles. And as I said, I'm Steve Wormiel. I'm a professor at American University, Washington College of Law, and a former Supreme Court reporter for the Wall Street Journal many years ago. I want to set the stage briefly for our conversation and then turn it over to our panelists. We ask that when you have questions that you put them in the Q&A, and we will look at that toward the end of the program and leave time for us to answer questions. Please don't try to put them in the chat. We would prefer that you put them in the Q&A. There will be a video of this session that our tech people will perfect in the next few days, and then the ABA Division for Public Education will post that video on their website, and we'll post it at WCL as well. So let me get started. We are meeting on what I would consider an historic day. It's historic because, as far as I know, so far today, no justice has spoken out about the legitimacy of the court. And that's unique in the last several weeks. But seriously, this is an extraordinary moment for the Supreme Court. I'm not sure there has ever been, at least in my memory, and my memory is pretty long on this subject, at least in my memory, there's never been a summer in which the court was as much in the headlines as the last 3 months. Between reaction to the Dobbs abortion decision and other rulings, polling and commentary about the Dobbs decision and the impact on the upcoming election, justices discussing in public the credibility and legitimacy of the court and criticism of the institution. We'll ask the panelists in a minute to reflect on the last term and what's been going on, but let me make a couple of other quick points. First of all, and I guess with some pleasure, the court has announced that oral arguments will be open to the public for the first time in 2 years, but also that the court will continue to live stream the oral arguments, which didn't happen before when the arguments were in person. So that's I think, a great step forward for access to the court. After this really busy summer, the court comes back on the bench on Monday. The justices, by my calculations, have room on their calendar for 38 days of argument. If they heard 2 cases a day, that would be 76, which would yield or lead to 76 decisions. They are unlikely to get to that number. So far, they have only granted 27 of those 76 slots. If they follow recent practice, they're more likely to end up at about 55 rather than 76. And so they will be adding additional cases in the days and weeks ahead that will still be argued in this term. The 27 were granted last spring and are now set to be argued this fall. And then they will add additional cases. This will be done with the addition of the newest member of the court, Justice Ketanji Brown Jackson, who has her investiture ceremony tomorrow. That's really just a formality. She's already been sworn in July and has been doing the job all summer long. The investiture ceremony sort of makes it official. I wanted to mention one additional thing, and maybe we'll get to it in discussion a little bit later, but just in the last 2 weeks, a very important conflict among federal appeals courts has occurred involving the power of social media platforms, Twitter, Google, and so on, to engage in editorial judgment about what material can be posted and what they can take down, or whose accounts they can freeze. Florida and Texas both passed laws saying that the social media platforms couldn't do that. The federal appeals court that governs Florida, the 11th Circuit, struck down the Florida law. The federal appeals court that governs Texas, the 5th Circuit, upheld the Texas law. We can talk about this maybe more if we have time a little bit later, but that creates a split among the appeals courts, which makes it likely the Supreme Court will have to hear that dispute. And it's a huge issue in the question of what kind of free speech rights social media platforms have, what kind of authority they have to control the content of what they post, and so on. So hopefully we'll have time to come back to that. Let's turn to the panel. And first, let me ask each of our panelists if you would give us just a brief takeaway, something striking to you about last term, and then we're going to go through a series of what we think are the major cases for this term. So, Roman, let me start with you.
Now I'm doing it. Thank you, Steve, for having me. It's great to be here with all my fellow panelists. There's so much to say about the last term. I guess one point I would throw out there. I think last term sort of cemented the sort of balance of power across the court, and in particular the role of Justice Kavanaugh. I think Justice Kavanaugh sits sort of in the middle of the 9 justices in terms of his sort of jurisprudential philosophy and approach. And so if you're kind of counting votes as an advocate or as a court watcher, he's sort of the 5th vote. And it's very hard to win a case at the Supreme Court without getting Justice Kavanaugh on your side. I think the numbers bear that out. He was in the majority 95% of the cases. He only dissented 3 times. I think he sort of has a foot in either camp on the conservative leaning justices. He's with the chief in a lot of cases, sort of on prudential type grounds, maybe not willing to go as far as some of the other conservative justices. But then on substantive questions of law, when he disagrees with the chief, he's always seems to be in a more kind of conservative direction. And he disagrees with the chief more and joins with Alito and Gorsuch and Justice Thomas, although sometimes he doesn't quite go as far. Final thing I'll say, Justice Kavanaugh had two big concurrences last year in Bruin, the gun case, and in Dobbs. I think that's something we're likely to see going forward, where he issues a concurrence writing for himself, but a concurrence that will be looked at by court watchers with great attention because of his role in a critical critical vote in shaping the rules of law going forward.
Thank you very much. Kimberly.
Sure. Well, I think one takeaway that I have really piggybacks off of something you said at the top about the justices being in the headlines this summer. And that to me is the kind of shift in mood at the court and among the justices. You know, for a long time, we've heard the justices say that they're a unique institution in Washington because despite their differences, they get along really well, and that's important for the court to be able to have really considered judgment, to look at all sides of the case. But there's some indications, particularly after the leak of the Dobbs decision, that that is changing a bit. So we saw early on Justice Thomas give a speech in which he suggested that trust among the justices is waning, and that, you know, they're sort of looking over their shoulders after the leak. And more recently, we've seen Chief Justice Roberts and Justice Kagan, without specifically IDing each other, giving kind of competing notions about the legitimacy of the court. And then just yesterday, Justice Alito gave a comment to the Wall Street Journal saying that it crosses the line to really question the court's legitimacy based on the decisions that it makes. You know, I think you could twist yourself into a pretzel trying to say, oh, these are all consistent statements. But to me, it really seems like something is going on at the Supreme Court amongst the justices. And looking forward, I'm going to be watching to see how that plays out this term. And I don't think we're quite at Congress level yet, but all does not seem right among the justices after last term.
Thank you. Erwin.
Such a pleasure to be a part of this panel. The takeaway I have from last term is how far the court moved the law to the right with regard to abortion rights, administrative law, gun rights, separation of church and state. These were not incremental changes. These were dramatic. These were not minor issues of law. These were enormously important for people's lives and for our society. It shows the profound impact of Donald Trump having appointed 3 justices to the court. If Hillary Clinton had won in 2016, none of these cases would have come out this way.
Thank you. And Maya.
Thank you so much. I'm really delighted to be here. My comment really follows on Erwin's. I think the theme from last term was sort of now is the time. We have the power, and now is the time to move the law in the direction that at least 5 justices in the majority see fit. You know, it's striking to hear Roman describe Justice Kavanaugh as now the center of the court and the swing vote. I mean, that just really tells you how far right, like it's all relative, what's center and how far right the court has moved. That is most obvious in the Dobbs decision in overturning Roe versus Wade, but I think Dobbs is just a harbinger of what's to come, particularly when it comes to civil rights.
All right. Thank you all for getting us started. Maya, I'm going to continue with you, although there isn't an abortion decision to be argued yet on the docket. So much has happened in the wake of Dobbs that we thought we probably ought to start there with an update and kind of what lies ahead.
Yeah, so obviously Dobbs outright overturned Roe and Casey, which rested on a long line of precedents holding that liberty of the Due Process Clause prevents the government from interfering in private medical and familial decisions. And the rationale in the case for the majority was that unenumerated rights that have long been protected by the Due Process Clause will no longer be protected unless they are deeply rooted in the nation's history. And in articulating that rationale, the justices in the majority claimed to be getting the court out of the business of deciding constitutional questions on abortion and said, you know, we're just going to leave this to the democratic process and we're getting out of this business. But in just 3 short months or a few short months after Dobbs, it's pretty clear that the court is going to be mired in questions surrounding abortion in the years to come. There's already 3 questions that are on the horizon for the court. The first is a question about fetal personhood. The second second is a brewing conflict on the vertical axis of federalism, of federal preemption of state abortion restrictions. And the third issue deals with the horizontal axis of interstate conflict. And that's in part dealing with another unenumerated right, the right to interstate travel. So as to the first question about fetal personhood, throughout the Dobbs opinion, there's a lot of rhetoric about abortion as the destruction of unborn life, and that makes abortion different than other substantive due process rights. That rhetoric seems to lay the groundwork for a constitutional basis for fetal personhood, which has been a longstanding goal of the anti-abortion movement. On September 1st, a cert petition was filed out of Rhode Island asking the court to rule on fetal personhood in light of Dobbs, and arguing that addressing whether the 14th Amendment protects fetuses as persons, arguing that that's inevitable after Dobbs, that that's the question Dobbs teed up and the court has to answer it. Now, I think it's pretty unlikely the court has an appetite to address the fetal personhood issue anytime soon. And again, as Rahman noted, Justice Kavanaugh's separate concurrence was important here. He indicated in his concurring opinion in Dobbs that he would be reluctant to declare that the Constitution establishes fetal personhood. The questions that the court seems more likely to have to address in the near future are the questions about federal state conflict and interstate conflict over abortion. So on the federal state axis of conflict, one issue that is already working its way up the federal courts is whether EMTALA, which is a federal law requiring emergency medical treatment for all patients, whether that law preempts some state abortion bans to some extent. So we've already begun to see the public health fallout in these last few months since the Dobbs decision was issued. More than a dozen states have now banned most abortions. We expect up to as many as 26 states will ban or severely restrict access to abortion care in the coming year. A few of these states that now have total or near total bans on abortion care have no health exception or very narrow health exceptions. And as a result, patients have not been able to receive timely pregnancy-related care in these states. So, for example, care for miscarriage or for an ectopic pregnancy. So because of this, the Federal Department of Health and Human Services issued new guidance on EMTALA, the Emergency Medical Treatment and Active Labor Act. So this law says that hospitals with emergency departments that receive federal funding have to provide emergency stabilizing care, and that includes abortion care if it's necessary to stabilize a pregnant patient. So HHS's new guidance specifically talks about abortion, and it says that EMTALA can and does preempt a state's abortion ban to some extent, that hospital emergency departments may be required to perform abortion procedures under federal law under certain circumstances pursuant to EMTALA's protections. We already have sort of a brewing split between two federal district courts. So there's a district court opinion out of Idaho and out of Texas, and they issued conflicting decisions on whether EMTALA preempts state abortion bans that have narrow health exceptions. So in Idaho, it was actually the federal government that sued the state, saying that its abortion law was preempted by EMTALA. The Idaho law has no exceptions for the health of the patient at all. Instead, if an abortion is performed, the physician can argue only as an affirmative defense that the abortion was necessary to prevent death of the patient. So the district court in Idaho said, no, EMTALA's preemption provision applies. And the court said, the problem is the Idaho statute makes it a crime to offer the kind of stabilizing care required by EMTALA, and the affirmative defense provision doesn't really satisfy that, right? Because even if the physician can raise as an affirmative defense, I had to do this to prevent death, it's still impossible to provide an abortion without also committing a crime. But more broadly, the Idaho court said that this ban is an obstacle to the achievement of Congress's goals under EMTALA, and that it's therefore preempted under an obstacle preemption theory. And what the court stressed is that Congress's purpose in promulgating EMTALA was to say we need a bare minimum of emergency care in all our hospitals, all these hospitals that get Medicare funding. And the problem was that Idaho statutes was having a chilling effect on physicians providing emergency care, emergency abortion care, and that would not be the bare minimum that Congress intended. In contrast, a district court in Texas held that EMTALA does not preempt Texas's abortion ban. There are some differences between these two state abortion bans. Texas law does have a health exception, but it is very narrow, and it is one that, like Idaho, has had a chilling effect on providing emergency care to pregnant patients. But in the Texas case, it was the state of Texas that sued the federal government. Here, the district court said, we agree with Texas, and among other things, it said HHS exceeded its statutory authority in issuing this guidance, but it also read EMTALA much more narrowly than the Idaho court, and it held that it did not conflict with the Texas abortion ban under an obstacle preemption theory. So these cases about federal preemption of abortion bans are, I think, definitely going to be making their way up to the court. Texas is also at the center of questions on the horizontal axis of interstate conflict. In particular, one question about the scope of the constitutional right to travel. I think questions about the right to travel are inevitably going to make their way up to the court, as we have a patchwork of state abortion bans that are forcing pregnant people to travel for their healthcare and healthcare providers to travel to provide abortion care. Again, we can look at Justice Kavanaugh's concurring opinion in Dobbs. He mentioned in there, he believes the constitutional right to travel would prevent a state from barring a resident from traveling to another state to obtain abortion care. There's good reason to fear that some states will do this. A Missouri legislator had already proposed such a law banning interstate travel for abortion care. But even without a direct ban on interstate travel for abortion, there are a lot of open questions about the scope of the right to travel, given that states have ways to indirectly impinge on travel for abortion care, as Texas officials have already threatened to do. So I should note that Texas now has three separate laws in effect that ban abortion care. Two are criminal laws. One is a trigger law, one is a pre-bro law, and they also have SB8, which is the civil bounty hunter law. So the pre-law criminal abortion ban is a law from 1925, carries up to criminal penalties up to 5 years in prison. And Texas says it's also for anyone who assists in an abortion, who aids or abets abortion care under the law. Now, there are a number of reproductive rights groups in Texas that help to fund travel for out-of-state abortion care, that help with the logistics of travel. There's empirical evidence showing that such help is necessary for many abortion patients to travel for care. And so these abortion funds have filed a federal lawsuit against Texas state officials to head off possible prosecution for helping Texans gain access to legal abortions in other states. And among other claims in this federal lawsuit, the plaintiffs are arguing that threatening to enforce Texas abortion bans against those who help people travel, or against doctors who travel out of state to provide abortion care lawfully out of state, that impinges on the right to interstate travel. And all these funds have, for the moment, stopped providing any help for interstate travel because their fear of being prosecuted is well founded. For one example, is Texas lawmakers sent a letter to the law firm Sidley Austin threatening legal action for helping their employees pay for out-of-state abortion care. Sidley was one of many employers that announced plans to financially support employees who needed to undertake interstate travel for abortion care. So we are definitely going to see questions about the scope of the right to interstate travel, among other claims related to interstate travel, like Dormant Commerce Clause claims, make their way to the court. So I want to just wrap up by noting one other thing about Justice Alito's opinion in Dobbs. He has some lines in there. He says women are not without electoral or political power. He stressed that women vote at a higher rate than men. And he indicated that if women don't like this decision, they can change it with their vote. So I think it's important to keep in mind the connections between the Dobbs decision and the voting rights cases that we'll be discussing shortly. Dobbs really emphasized that decisions around abortion should be left to the democratic process. And so we really need to pay attention to what's happening with the various kinds of voting restrictions and changes to the electoral process that are making their way up to the Supreme Court and coming through the federal courts. So I will end there. Thank you.
Thank you so much, Maya. Anybody want to add any comments? All right, if not, we'll move on to Roman, who's going to tell us about two very important affirmative action cases and what the outlook is, I guess. Are these the Dobbs cases of the next court term?
Well, it seems that that overturning Roe versus Wade was high profile, but there's a lot more to come in terms of high profile cases. And so, as we turn to this coming term, we're going to be talking about a number of these cases, but the ones that I'm going to lead off with are, as Steve was saying, the two affirmative action cases, both of which are challenges to affirmative action programs. One of them is challenging the Harvard College undergraduate admissions program. The other one is a challenge to the University of North Carolina's program. Technically, the Harvard challenge is under a federal statute, Title VI, and the North Carolina challenge is under the Equal Protection Clause. But because Title VI has been interpreted to incorporate Equal Protection Clause standards, both cases seem to ultimately sort of turn on the constitutionality of affirmative action, at least in the context of higher education. And so the way that these key cases are teed up, they have sort of two questions presented in them. And the first question is whether the Supreme Court should overturn its earlier decision from about almost 20 years ago in the Grutter versus Bollinger case. That case recognized that diversity and promoting diversity in higher education is a compelling interest that would allow for race-conscious admissions policies, affirmative action policies, to be justifiable under the Constitution. The challengers to the policies at North Carolina and Harvard say that Grutter should be overruled. But they also say that even if Grutter isn't overruled, and this is the second question presented, they say that under existing precedent, the particular admissions plans in both cases do not satisfy strict scrutiny and do not actually satisfy the test, even under Grutter, because of the way that those two programs are set up in their history. And so, just to kind of walk through a couple of the arguments very quickly. And the arguments, the challengers in both cases are the same group. It's an entity called the Students for Fair Admissions. It's a group that was set up to bring these kinds of challenges to push a sort of race-blind vision of college admissions generally, and they've sued a number of institutions, including the two here. The basic argument that the Students for Fair Admissions is making is that Grutter should be overruled because under the text of the Equal Protection Clause and under decisions like Brown versus Board of Education, the Constitution essentially denies institutions of higher education the right to use race as a factor in doling out educational opportunity. So the big push in the briefs is for a vision of a colorblind Constitution, and they say that look, overturning precedent is okay, and in fact, Brown versus Board of Education overturned Plessy versus Ferguson, of course. They argue that the decisions like Grutter, which allowed for affirmative action programs and race-conscious admissions, depart from the original meaning of the 14th Amendment's text, which doesn't have any exceptions in it. It's an issue with Brown. It sort of originated out of efforts, the kinds of diversity type rationales that were put forward in Grutter originated out of efforts 100 years ago when there was a concern that there were too many Jews being admitted, especially at places like Harvard. And they say that sort of colors the roots of these holistic admissions programs. They make a bunch of other challenges, but essentially, I think the argument against Grutter is that it was really, really wrong, that no legitimate reliance interests have developed, in part because you can't legitimately rely on the right to treat people differently on the basis of race, and also because Grutter itself suggested that it's holding approving diversity as a compelling interest maybe would no longer need to be the case in 25 years or a few years before. We're not quite at the 25-year mark, but we're getting close. The challengers also make these arguments that under the existing precedent, the programs fail strict scrutiny. With respect to the Harvard program, it's especially interesting. They were able to develop in the course of the litigation a lot of the admissions data at Harvard, which seems to show sort of disparate treatment, at least in the aggregate, of certain ethnic groups. Asian Americans in particular seem to have been given very low sort of personal quality rating scores as one component of the holistic admissions process. And the argument that the Students for Fair Admissions makes is that is sort of the mechanism by which Harvard is sort of balancing out its classes by race. It's taking Asian Americans who overperform other groups with respect to academic performance, and then sort of like penalizing them on the personal traits, so as to balance them out and try to kind of cap Asian American admissions. Harvard, of course, vigorously disputes that characterization of the statistics, and there's a real battle of statisticians that is sort of interesting, but a little bit hard to follow in the briefing. On the other side, Harvard and the University of North Carolina argue that, of course, we have precedent. We've got the Bakke case from the late 70s. You've got Grutter. You've got the Fisher cases from recent years, which refused to overturn Grutter. And they say that the Constitution promises equal protection of the laws, that doesn't mean that you can't, in certain circumstances, take account of race in very targeted and careful ways. They say that the text of the 14th Amendment and the history of the 14th Amendment shows that at the time the 14th Amendment was passed, Congress was enacting certain types of race-conscious programs like the Freedmen's Bureau Act and others that gave preferences based on race or preferences based on former enslaved status. And that those kinds of programs, which are intended to be inclusive as opposed to exclusive, or are not intended to be based on animus against certain races, that those are the kinds of things that are permitted within the Equal Protection Clause. They also point out that that the challenger's interpretation of Brown versus Board of Education really doesn't rely on the language of Brown versus Board of Education itself, but rather the Chief Justice Roberts' interpretation of Brown in a case called Parents Involved from about 15 years ago. They also, in addition to their sort of historical case, they point out that the other side, although it sort of talks the talk of originalism, doesn't really have a lot of historical analysis and instead relies just on the language of the Equal Protection Clause and the Chief's interpretation of Brown in Parents Involved. In addition to that, they make a series of policy arguments about the positive consequences of diversity, and they emphasize the reliance interests of universities across the country that have adopted these types of admissions programs, in part because the Supreme Court has told them that it's okay to do so. I'll just close by making a couple quick observations of the case, which I think is very interesting, both because of its intrinsic significance, but also because it sort of touches on a lot of different themes that have been debated in recent months and years about the Supreme Court. So one thing that this case implicates is obviously, it's a test case for the 6-3 Republican appointed court. Erwin and Maya and Kimberly and others, we've sort of, and Steve too, we've sort of talked about the fact that we now have a court that is sort of more unbalanced than it has been in the past. I think this is the kind of case that potentially could make big law when presented to a court of that makeup. I think the role of the Chief Justice is something that's gotten a lot of attention recently. The chief in a number of cases, including most notably Dobbs, has played a role sort of trying to be in the middle, trying to broker compromise, reach narrower rulings, not being willing to overturn precedent. This case might put him in a different position because he does have a history in this area of talking about sort of the colorblind Constitution and talking about race-based affirmative action. He's been very skeptical of these programs over and over again in decisions, and then also when he was a lawyer in the government in the 1980s. So this might be a case where actually we don't see the chief playing the same role that he's been trying to play in the last couple of years. Precedent. This case obviously involves the potential overturning of a major precedent. That seems to be a big deal these days, or a trend these days with some other decisions like Dobbs. And so it will be interesting to see if the court is willing to overturn another major precedent back to back with Dobbs. And then the final thing I'll say is I do think that this case implicates interesting questions about sort of prudence, how broadly or narrowly to write decisions. I think you can imagine a scenario in which students for fair admissions, the challengers here, win, but they could win narrowly or they could win broadly. They could win under the existing precedent. They could win by overturning Grutter. But even if they do succeed in overturning Grutter, they could do it in a way that makes it very hard for universities to sort of replace their current affirmative action type programs with other programs that are maybe not as explicitly race conscious, but are designed in part to promote diversity and kind of reach a diverse, develop and build diverse classes. For example, some universities in some states have in part out of a desire to ensure racial diversity, have adopted programs where, for example, like the top 10% of every high school is admitted to a public university. That's not an expressly race-based criteria, but it's adopted in part out of a desire to promote diversity because high schools are distributed in different neighborhoods, and that adopting that kind of policy will promote diversity. And so we'll have to see whether the court, even if it does overturn Grutter, sort of casts a shadow over those types of programs or allows for such programs to continue as long as they're not explicitly treating individuals in their individual applications differently on the basis of race. I will stop there. It'll be a very interesting decision. It's going to be argued on October 31st. Justice Jackson is recused from the Harvard case, but she and all the other justices will be participating in the North Carolina case. And that's definitely going to be one to watch this term.
Roman, thank you. Comments from other panelists? Erwin.
I think that was just a terrific description of these cases. I don't think that many liberal or conservative much doubt about what the Supreme Court's going to do. I think the conventional wisdom is that there's now clearly a majority to overrule Bakke and Grutter and Fisher. I would just add a few comments. First, picking up with what was just left off, I think it's a real key question of how will the court write the opinion when it does that? Will they write the opinion to say that diversity is not a compelling interest? Or will they write the opinion to say that the Constitution requires colorblindness? If they do the latter, the implications are enormous, including in terms of whether disparate impact liability will continue to be allowed in any area of law. Second, I think it's important to stress what this is likely to mean in terms of originalism. Last term, originalism was so ascendant. You think of the gun case, Bruin, you think of the school prayer case, Kennedy, where the court adopted originalism. With regard to affirmative action, if you follow originalism, I think that there's no way to overrule Bakke and Grutter and Fisher. As was just pointed out, the Congress that ratified the 14th Amendment adopted many race-conscious programs like the Freedmen's Bureau. It's been striking in past affirmative action cases when Justices Scalia and Thomas, originalist dissent, they never talk about original meaning. And so if the court here overrules these earlier cases and doesn't in any way invoke originalism, I think will certainly fuel the criticism that they use originalism when it serves their purposes and ignore it when it doesn't. And finally, I have to speak as a law school dean. I think what we're going to see when the court overrules these cases is a devastating effect on diversity throughout the country. Some states have already eliminated affirmative action. California did in Proposition 209 in 1996. States like Michigan and Washington State have done so. In California, UCLA, for its undergraduate population, didn't reach the pre-1996 levels of diversity for over 20 years. In the year after Prop 209 was adopted, there was one Black student at my law school, Berkeley. Now, these schools have found other ways to achieve diversity. Whether they'll be allowed will depend on how the court writes the opinion, but also it will take time, it will take concerted effort. The human effects of these decisions will be enormous.
Thank you, Erwin. Thank you, Roman and Erwin both. Anybody else? If not, we will turn to Kimberly, who has a quite fascinating case to talk about involving the Indian Child Welfare Act.
That's right. I'm going to be talking about Holland versus Brackeen. And I think, man, in any other term, this is a case that people would be talking about a lot, that people would already know about, but situated in a case of affirmative action and voting rights and some of the other cases we're talking about, it's flown pretty under the radar. But as you mentioned, this is a challenge to the Indian Child Welfare Act, which became law in 1978. And its stated purpose is to prevent the breakup of Native families and, importantly, to set minimum federal standards for removing Native children from their homes. And a brief by the tribes in this case really sets out the problem that Congress was trying to tackle with this piece of legislation. So they note that at the time, more than a quarter of Native children were taken from their homes and placed in foster care or put up for adoption. And that was happening largely because of cultural differences between child rearing in tribes. And so the tribes say this has been really successful, but they urge the Supreme Court not to strike it down because they say there's still work to be done. And they point out that Native kids still are overrepresented in the foster care system. So these are a set of challenges brought by individuals who want to adopt or want to put a Native child up for adoption, but have faced barriers under ICWA, as it is known, that hasn't always blocked these adoptions, but it has been something that these individuals say they have to overcome. It's also being challenged by a handful of states, which is led by Texas. So one thing I'll say at the top is that the Supreme Court seemed to invite these suits, and it did so in a 2013 case called Baby Girl, in which the court narrowly held that ICWA didn't apply to that particular circumstance. But in doing so, some of the justices highlighted some potential constitutional problems if they were to read the statute more broadly. And after that, and after some renewed interest by the Bureau of Indian Affairs, we've seen a wave of suits challenging what for decades has stood as good law. And so here, the lower court struck down portions of ICWA, and the full Fifth Circuit heard the case en banc. I was trying to think of the technical term for the en banc ruling. I think the legal term is it's a mess. No one opinion garnered a majority on every point, and that's probably because there are just so many issues in the case. I think it makes it really hard to try to guess what particular issues the individual justices are going to grasp onto and how that's going to frame the way that they look at the case. But I'll just highlight some of the major arguments that the parties are making. So there's a threshold argument that the United States never had the authority to enact ICWA in the first place. And this argument is based on the Indian Commerce Clause, which says, in the Constitution that Congress can regulate commerce with tribes. The challengers here urge the Supreme Court to look at that narrowly and to say things, to say only things like trade can be regulated, or to put some geographical limits on the Indian Commerce Clause. But the US says that it's not just the Indian Commerce Clause, it's other constitutional provisions, and importantly, it's history and tradition, which shows that the United States really has broad plenary power whenever it's dealing with Native populations. And they tell the court that undoing, the federal government's authority in this case could wreak havoc on other laws dealing with Indian tribes. So that's one of the issues. Another one that I think will be prominently discussed in arguments are equal protection challenges. And here the challengers don't really dispute the purpose of the law, but they say, regardless of whether or not this is intended to help Native populations, it's a classification on the basis of race. And those are suspect, and the government here just doesn't have a good enough reason to make those sorts of classifications. The tribes, for their part, say, this isn't a racial classification. In fact, it's a political one. And they note that, tribes are separate sovereigns. So when the United States is making these distinctions, it's doing so on the basis of political grounds, and that those just have to have a rational basis in the law, and that's something that can easily be satisfied by ICWA. I think that's an argument during oral arguments that I'm going to be closely watching a couple of the justices on, particularly Justices Gorsuch and Barrett, because I think it could give them an appealing way of kind of not having to, they're suspect of these racial classifications, but they may be sympathetic to what's going on here, what the federal government is trying to do. So looking to see if that picks up any traction. And then the last thing I'll just say is, there are a couple of constitutional challenges to the merits beyond equal protection, things like commandeering and non-delegation. This is the idea that Texas raises that says the federal government can't make state courts and state officials do the bidding of the federal government. That's something that's left to the states. There's some counter arguments there that I won't go into. But the last one is non-delegation. This is the idea that there are certain things that Congress just cannot delegate to other people. It cannot, it doesn't have the authority to give that power away. And this got some renewed attention after last term in an environmental law case, which talked about the major questions doctrine, which said, when Congress wants to do something big, it has to say so really clearly. It has to be really explicit. But there was some suggestion that there's this counter to that under the non-delegation doctrine, that even if Congress speaks very clearly, says exactly what it wants, there's just some things it can't do. So that's kind of a side issue that I think beyond the Indian Child Welfare Act will be, could have some renewed force in constitutional law under the current court. And that's what I've got for Brackeen. I guess I should say, I think that it's interesting to note that we haven't filled out the docket yet. We're far from it. As you mentioned at the top, just 27 cases. But one theme I really see coming through this term is a focus on race and how the government and how private entities use race as a classification, and what the Supreme Court is going to do with that overall.
Thank you, Kimberly. Other comments? All right. Speaking of race, Erwin's going to talk about a couple of voting rights cases, one of which is specifically focuses on race, and the other quite profound implications for our democratic system.
Yes, let me do them in the reverse order you just mentioned. If you ask me what case I'm most worried about on the docket this term, it would be Moore versus Harper. It involves the so-called independent state legislature theory. The Republicans controlled the North Carolina state legislature. They again engaged in very deliberate partisan gerrymandering. As a result, Republicans would likely win 10 of 14 congressional seats from North Carolina. North Carolina has been part of other partisan gerrymandering litigation. You might remember Rucho versus Common Cause a few years ago, where the Supreme Court said the challenges to partisan gerrymandering are non-justiciable political questions in federal courts. That involved Republicans controlling 10 of 13 seats in Congress. Now, North Carolina is a purple state. It went for Obama in 2008, for Romney in 2012, Trump in 2016, Trump in 2020, but always by close margins. In 2020, Trump beat Biden by 1.65%. But partisan gerrymandering, thanks to computer programs, can be very successful. The North Carolina Supreme Court found that this most recent partisan gerrymandering violated the North Carolina Constitution. It created a commission to draw new districts that reflected the politics in the state. The challengers, the defenders of the partisan gerrymandering, have gone to the Supreme Court and said, under Article 1, Section 4 of the Constitution, it's for the legislature of the state to determine the time, place, and manner of elections. Therefore, courts can't enforce state constitutions. What the North Carolina Supreme Court did here was impermissible. There's another provision of the Constitution that also is part of this independent state legislature theory. It's found in Article 2, Section 1, that says it's the legislature of each state that determines who gets that state's electors in the Electoral College. The independent state legislature theory was first articulated in the Supreme Court in a concurring opinion in Bush versus Gore. It's Chief Justice Rehnquist and Justice Scalia and Thomas that endorsed it, that said it should be for the Florida legislature to decide who gets Florida's electors. The courts have no role whatsoever. The defenders of the independent state legislature theory say it's in the text of the Constitution. Legislature means legislature. The opponents of the independent state legislature theory say always courts get to enforce constitutions. Where Congress has powers under the US Constitution, the courts still get to decide if they're constitutional. When state legislatures have power under state constitutions, the state courts get to decide whether or not it's permissible. And they point to a 2015 case, Arizona State Legislature versus Arizona Districting Commission, where the court rejected the independent state legislature theory. Obviously, this is enormously important in terms of the power of state courts with regard to partisan gerrymandering, but also if the court adopts the independent state legislature theory, it would likely affect the other provision with regard to presidential elections. Imagine an election as close as 2020 and 2024. And imagine a few states, make them hypothetically Wisconsin, Georgia, Arizona, with Republican-controlled state legislatures. And imagine those state legislatures decide to allocate the electors of that state to the Republican candidate, even though the Democrat won the popular vote. And imagine that decides the outcome of the election. That could be the implications of the independent state legislature theory. And I fear if that would happen, our country would literally come apart. So the consequences, the stakes in this case are so enormous. The other case that I want to talk about is the one that Steve, you mentioned initially in introducing me. It's Merrill versus Milligan that's going to be argued next Tuesday in the court. And it's already got some history in the court that's significant. Every state engages in redistricting after the census. This involves the redistricting of Alabama congressional seats after the 2020 election. The way in which districts were drawn, there would be a Black majority in one of 7 congressional districts. And given the history of racially polarized voting in Alabama, likely there'd only be one Black representative elected from Alabama. But Black individuals are 27% of the population in Alabama. A 3-judge federal court found that the districting for congressional seats in Alabama violated the Voting Rights Act of 1965. At this moment in time, I think it's worth mentioning, 2 of the 3 judges on that panel were appointed to the court by President Donald Trump, the other appointed by President Bill Clinton. The Supreme Court stepped in and stayed the use of the new districts, allowing the discriminatory districts to be used for the primary and general election this year. There was no opinion, it was 5-4. It was no opinion written for the 5. Justice Kavanaugh wrote a separate concurring opinion saying, under a 2007 ruling in Purcell versus Gonzalez, federal courts should not get involved in elections soon before they occur. The so-called Purcell principle in the past had said, well, days before an election, a federal court shouldn't get involved. This was months before the primary and many months before the general election. This would then seem to mean that federal courts can't get involved whenever new districts are drawn, because inevitably it would be soon before the election. So in this way, Merrill versus Milligan has real consequences for the future. And fitting what we said earlier, Chief Justice Roberts here joined the dissent of Breyer, Sotomayor, and Kagan. The court then granted review on the merits in Merrill versus Milligan, which is going to be heard next Tuesday. And the Supreme Court has already narrowed, maybe even gutted aspects of the Voting Rights Act. In Shelby County versus Holder in 2013, the court declared unconstitutional the pre-clearance requirements, the provisions of the Voting Rights Act that said that jurisdictions with a history of race discrimination voting need to get pre-approval before significant changes. In 2021, in Brnovich versus Democratic National Committee, the Supreme Court made it much harder to prove that regulation of elections, with regard to the time, place, or manner, violate the Voting Rights Act. This is the court taking up districting, and when it violates the Voting Rights Act, the court might make it much more difficult to prove that districting violates the Voting Rights Act. Some have even said this might be a case where the court takes up the issue of whether or not disparate impact liability with regard to voting violates equal protection, because it requires attention with regard to race. So it's quite a different set of issues than Moore versus Harper, but enormously important as well.
Thank you, Erwin. Other comments, thoughts? All right, so I'm going to talk quickly about one case, and then we'll kind of open it up for a little discussion, and then take some questions. The case is called 303 Creative versus Alinas. It is in one sense a sequel, and in another sense not. It is in one sense a sequel to the well-known Masterpiece Cake Shop case. That was the case in which the court was asked to rule on the situation of a baker in Colorado who didn't want to make special order wedding cakes for same-sex marriages. And the court, in a sense, ducked the issue that was at the heart of that case, and may duck the issue that one might have thought would be at the heart of this case too. I mean, the overarching question that I think needs to be decided by the court at some point is what happens when there is a clash between religious values and state anti-discrimination laws, particularly with respect to how LGBTQ individuals or couples are treated by businesses in various states. Masterpiece Cake Shop ducked that issue because the court said the Colorado Human Rights Commission expressed hostility toward the baker's religious views, and that suggested a bias. And so they didn't really get to the question of, what should be the impact of the state human rights law. They just ruled that the baker was entitled to win that case because of the bias expressed by a member of the commission. So here we have Lori Smith, a graphic designer. She's got her own graphic design company, also in Colorado. She spent a lot of time doing corporate website design. She now wants to expand into wedding website design. She says that because of her religious views, she believes that God recognizes marriage as only between a man and a woman, and that she can't provide websites to same-sex marriages. She says she'll provide websites for LGBTQ individuals, but not for same-sex marriage. That ostensibly seems to violate the Colorado human rights law or anti-discrimination law on two grounds. One is that she is a public accommodation. She is a business that serves the public. And under the Colorado law, public accommodations are supposed to provide their services on a non-discriminatory basis to any customers. She doesn't want to do that. She's refusing to do that. The Colorado law also says that you can't post a statement that says you're planning to discriminate. And she wanted to do that. She wanted to post a statement on the website saying, I'll design a website for anybody who'll pay me, but not for same-sex marriages. She filed what's called a pre-enforcement suit to try to get the courts to determine whether her rights are being violated. The lower courts ruled against her, in particular the 10th Circuit based in Denver. The 10th Circuit said that her website design services are speech covered by the free speech clause of the First Amendment, but that the state of Colorado had a sufficiently strong interest in assuring that all individuals on a non-discriminatory basis have access to her services, and that interest on the part of the state was strong enough to overcome her First Amendment claim. Now, she also claimed that this violated her religious freedom under the free exercise clause. The 10th Circuit also found against her on that issue. She came to the Supreme Court and asked the Supreme Court to decide whether her free speech rights were violated, whether her free exercise rights were violated, and then whether the court should overrule a 1990 precedent that says if a law is a neutral, generally applicable law, it doesn't violate the First Amendment. There's no requirement that there be an exception under the First Amendment. When the Supreme Court granted review last spring, it agreed to review only the free speech question and not any of the religion clause questions. So in an odd sense, and this is what I meant by my comment at the beginning about sort of a sequel, this is another instance in which the Supreme Court it's going to decide an extremely important issue, but it may not decide the most important issue, which is pitting religious values against anti-discrimination laws. I think, and I invite others to comment, I think this makes it easier for the court. Now, the parties don't present it as an easy argument. The state and many friend of the court briefs supporting the state say this is not about speech, it's about conduct. That her refusal to serve is an action, it's not expression. And it's well established in First Amendment law that if you're regulating conduct, not the content of the speech, the court has more leeway. The First Amendment doesn't require as rigorous a review, so that the state would have more leeway to regulate conduct and justify that regulation. She argues, and also has many friend of the court briefs on her side, although ironically, an overwhelming number of the briefs on her side are from religious organizations, even though the court said we're not deciding the free exercise issue. But she argues that this is basically compelling her to speak against her wishes and against her views, and that violates a core First Amendment principle. So the question is, which of those scenarios will the court buy? Is this conduct subject to a lower standard and more discretion for the state, or is this speech subject to strict review by the court and less leeway for the state? And then what does all this mean about the religion clauses? You know, why is the court, which seems gung-ho to get to this issue, why is it not getting to this issue? The case isn't set for argument yet, which I assume, Kimberly, correct me if I'm wrong, but I assume that means it'll probably be argued in December. But they just haven't released that schedule yet. But I think enormously important ramifications, even though I think the court has made it easier for itself to rule in her favor by saying that this is compelled speech. And it would have been harder for the court to do that if they were deciding the religion issue. So I will see if anybody wants to add anything on that case. Erwin?
That's okay. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to engage in discrimination. For over a half century, the Supreme Court has consistently favored equality over the freedom to discriminate. But I think that the court here is likely to make the opposite choice. And then we need to think about the implications. Certainly the implications about people to be able to discriminate against gays and lesbians if they claim a speech interest or free exercise religion. But why would it just be limited there? Why couldn't somebody on the basis of their beliefs, their speech, their religion, discriminate on the basis of race, discriminate on the basis of sex? And I think we're seeing these cases coming up in the workplace context where employers are saying, my religious beliefs mean that I shouldn't have to hire or employ a gay, lesbian, transgender individual. But why wouldn't that mean that they don't have to employ a Black individual or a woman if that's against their beliefs? That's why I think the consequences of this are so enormous.
Roman, I saw you leaning in. Does that mean you want to say something? Please go ahead.
No, I'll jump in just on one point. I mean, I do think that it's possible. I think Erwin's concern is possible that, you know, you could imagine a slippery slope there. I also think you could imagine a way of resolving this case that's a lot narrower, which essentially says that there's certain types of businesses that are like inherently expressive, and that there's an especially acute problem with telling businesses that are engaged in the business of like producing speech, for example, creating a website to celebrate something, and telling them that they have to communicate a message with that expression that they sincerely disagree with. And that seems to be, I think, a very serious concern to anyone who would think seriously about free speech, even though obviously there are important equality interests on the other side as well.
And that's certainly part of what the website designers, lawyers, and her supporters are arguing, that there ought to be an exception carved out. A lot of criticism of that on the other side. Kimberly, did you want to add something?
Yeah, I did. I don't think that this is going to come up in this particular case because it is, as you mentioned, just limited to the speech issues. But one thing that the Supreme Court has said in looking at these cases in the religious context is that you cannot question someone's sincerely held religious belief. That's just not something that the court does. And it's stuck to that, except last term when religion came up in the context of capital cases. And there we saw the justices really question whether or not the death row inmate was expressing a sincerely held belief. And, I suspect the court will add more religion cases to its docket and avoid that issue here. But I wonder if there's some appetite among the justices to kind of revisit this idea that, sincerely held religious beliefs are just not something the court's going to question.
And I'll just add one more thought, which is something that's been kind of bothering me for the last couple of court terms. And Erwin, you might agree with me here, that the court seems to be increasingly taking what ostensibly are religion cases and deciding them as matters of free speech discrimination, content regulation. They did it last term they had a case from Boston where Boston said we can't display a flag with a Christian cross on it. And Boston's reason was that would violate the Establishment Clause, among other reasons. But the court issued a decision that barely mentioned religion at all. The court said if you're refusing to display a Christian cross, you're discriminating on the basis of the content of the speech, and you can't do that under the Free Speech Clause. And that seems to play right into this 303 creative case, where it's a speech case, not a religion case, even though the speech is religion. It seems to be a trend that the court is jumping on. All right, we have a fair number of questions, and I think we ought to, as promised, turn to those. I'm going to open up the Q&A, and I don't know if my fellow panelists want to open up the Q&A. I'm not sure any of us, I certainly can't answer the first one. Roman, I don't know if you're following Mallory versus Norfolk Southern Railway. If not, I would doubt that we have anybody on the panel that can speak to that. But
I'm happy to take the next one down, which touches on the affirmative action cases, if that's helpful.
Sure, I think we'll try to do all the others, and apologies to the person asking about the Norfolk Southern Railway, but go ahead.
Yeah, so the second question is about whether the Supreme Court might decide the affirmative action cases on Title VI grounds, essentially under the statute instead of under the Equal Protection Clause. I think one problem with that is that the Equal Protection Clause, I think is the governing. I'm not sure the UNC case directly implicates the statute, but I'm not 100% sure of that. But it definitely implicates the Harvard case. But I think that that it's possible that you could see in the Harvard case a ruling on Title VI grounds, but it seems very unlikely to me for two main reasons. Number one, the court formally, and the doctrine formally on stare decisis and precedent is that that statutory precedents get more stare decisis effect and more stare decisis weight than constitutional precedents. And here you have in the Bakke decision a precedent on Title VI that says that Title VI turns on the Equal Protection Clause, such that I think it sort of like eliminates the premise of the question, such that you essentially have to reach the equal protection theory. Bakke is kind of an interesting case because there were 4 votes in Bakke to actually say that the affirmative action program was illegal under Title VI, and the dissent was written by Justice Stevens before he apparently changed views on some of these questions. But it seems unlikely that for that reason that that they would need to overturn a statutory precedent that sort of weighs pretty strongly against Title VI. I think more practically, though, the parties have not argued for that, and so it would look procedurally odd to kind of reach out and decide a case on statutory grounds where it hasn't been briefed and where the constitutional question really is front and center. So it's always possible. I actually think it's very interesting to talk about the statute here, which in some ways is more specific and easier to focus on than the vaguer Equal Protection Clause. But for those reasons, I think it's probably ultimately going to be a constitutional decision.
Kimberly says she can talk about the Mallory versus Norfolk Southern Railway case, so we'll let you do that. Thank you.
Sure. So this is a case about jurisdiction, and in particular jurisdiction with regard to businesses. I think just giving you a description of the facts will kind of tell you what's at issue here. So this involves a Virginia railroad, a Virginia worker um, who was injured and says he was injured because of some carcinogenics that he was exposed to while working, and he brought his case in Pennsylvania. And the court is really looking at whether or not that's fair to businesses to require them to be sued in states where the injuries didn't occur, even though they do substantial business within Pennsylvania. So the background here is that the Supreme Court in a series of recent cases has really been limiting the places, the states where people or where corporations can be sued. And the question asks about some unfairness to people within the states. And I think one level of unfairness that some of the amici in the case raise is that the court is kind of setting up a situation where individuals can be sued more easily in states where they're not residents than where corporations can be sued. And that it sort of tramples on the rights of states who, do want to hold companies accountable, for things that not only happen within their state, but could happen within their state. And so, yes, I think there is sort of this tension between fairness between individuals and businesses, although I'm not sure that that's something that's going to win the day in the court on this one.
Thank you, Kimberly. I see two different questions about the independent state legislature theory. Erwin, can we let you try to tackle those? The first one asks if there's a way to distinguish between the Article 1 provision and the Article 2 provision. And then, if I may, the other one says in a discussion on the National Constitution Center website, there was a suggestion that the court doesn't have to, even if it adopts the independent state legislature theory, it doesn't have to do it in its most extreme form. It doesn't have to set the state legislatures entirely free from the state constitution and state judicial systems. Is there a more nuanced way to do that? So can you tackle both of those?
Of course. As to the former question, I think there is a way to distinguish Article 1 and Article 2. Article 1 says that the state legislature shall determine the time, place, and manner of elections. I think it's possible to argue that drawing districts for Congress doesn't involve the time, place, manner of elections. And so that, therefore, even if you accept the independent state legislature theory, it wouldn't apply in this circumstance. It's not how the briefs are focusing it, but would give the court a narrow out that wouldn't then require whatever it says apply to Article 2. I should emphasize what this says is that state legislature determine the time, place, and manner of elections for Congress, the Senate, and the House. It doesn't relate to districting for state and local offices. I should point out too, though, that those who believe in the independent state legislature theory don't draw a distinction between Article 1 and Article 2. And so many believe if the court adopts this, in this case, it will carry over with regard to Article 2 as well. In terms of the latter question, there are many things that the court could do. For example, can a state legislature bind itself by law? What if a state legislature adopts a law that says the state will allocate its electors in the electoral college according to who wins the popular vote? Can a state court then enforce that? What if a state legislature delegates power to the courts, or state constitution delegates power to the courts? Can the courts then get involved? And if we really took the independent state legislature theory to the extreme, why can federal courts then enforce even the United States Constitution if this is left to the plenary power of state legislatures? And once we say federal courts can enforce the federal Constitution, can state courts enforce the federal Constitution? And if they can do that, why not the state Constitution as well? So all of this is implicated, and I agree with the second question. There's many different ways the court could adopt the independent state legislature more narrowly or more broadly.
Thank you, Erwin. We have a question about the social media cases I was talking about. Let me come back to that in a second. One person asks if, given the Fulton versus City of Philadelphia 2 years ago and the main school voucher case this past term, should we assume that the court's tilt toward religious liberty means that the 303 creative case has already been decided? I think it's already been decided on free speech grounds, not on religious liberty grounds. I think a majority of the court will say that this is that she's being compelled to speak against her views, but that's just my hunch. We did seem to have different views. Roman thought it could be a narrower grounds, and Erwin had a different take as well. Anybody want to chime in on that one? All right, let's go back to the social media question. As I set it up at the beginning, the Florida law saying that social media websites can't censor speech, that's sort of a loose way of describing what the law says, was declared unconstitutional by the 11th Circuit because it violates the free speech rights of the social media companies. Florida has already filed a cert petition just this week. Almost at the same time that Florida was filing the cert petition, a couple of days earlier, the Fifth Circuit upheld a similar Texas law, almost identical to the Florida law. So we have a split in the circuits. Thoughts about what's likely to happen. I mean, I was saying I think the Supreme Court almost certainly has to take the case. The timing is uncertain. The losers in the Texas case, the net choice conglomerate, may ask the court to expedite the case and get there along with Florida. They might want to drag their feet. They were not in any hurry. So unclear about the timing, but what about the substance? Anybody want to jump in?
There is one, I guess, tea leaf to read or clue. The Supreme Court already has had some involvement with this. The Fifth Circuit issued its ruling months before it released its opinion, which is quite unusual. And its ruling was that the Texas law is constitutional. And the media companies went to the Supreme Court, and the Supreme Court 5-4 went back to the district court order that enjoined the Texas law. Thomas, Alito, and Gorsuch, I think, made clear that they would be inclined to uphold the Texas law. Kagan, without an opinion, also dissented, but I think that was much more about the procedures of how it came to the court. The 11th Circuit opinion was written by Judge Kevin Newsom, who was a Trump appointee to the court. It is a very thorough and careful explanation for why saying that social media companies can't engage in content moderation violates their First Amendment rights. These are private companies, and telling them what they can and can't do would be like telling the New York Times or the Wall Street Journal or CNN what it can and can't publish. Judge Oldham wrote the opinion for the Fifth Circuit and has a very different perspective on all of this. And it almost treats these social media companies as if they're state actors. I'll read the tea leaves and predict that the Supreme Court's going to take the Florida case and it's going to affirm the Sixth Circuit by a 6-3 decision, just like when the matter came to the court with regard to the Texas law, you had the three dissenters, Thomas, Alito, and Gorsuch.
Anybody else?
Yeah, can I just add that, you talked about the timing is really uncertain there. I will say that yesterday the justices met in their so-called long conference where they consider, new cases to add to the docket. And there's sort of a parallel question about liability under Section 280 that is presented in that case. That case has to deal with whether or not social media companies can be held liable for hosting terrorist organizations when they carry out terror attacks. So if the justices want to take sort of a smaller bite at 2:30 before they get to the Florida and Texas cases, this is there. And I guess we should know in the next few days whether or not they will.
All right, I got three more questions here. I think that maybe we can try to do quickly for each of them. My colleague on the main campus, Professor Fabricant, wants to know if anybody could speak to any death penalty issues or major criminal procedure questions that are on the docket.
I don't have a death penalty or criminal procedure case, but I did file an amicus brief in a very interesting case called Percoco versus United States. It's a case about the prosecution of a staffer to the governor of New York who left his government employment to work on the re-election campaign of the governor, was outside public service, was then hired to essentially lobby or use his influence with people who were still in the government to achieve certain policy objectives, did that, and then immediately came back to his old job. And the Second Circuit held that that he owed even though he was no longer, even during the period of time when he was not a government official, he owed fiduciary duties to the public, such that he could violate the mail and wire fraud statutes for committing honest services fraud. And so the details of the case might not be that interesting, but I think it's an interesting sort of another sequel in a line of cases where the court is looking at the scope of certain criminal prohibitions, like the mail and wire fraud statutes in particular, and maybe trying to sort of rein in what they see as over exuberant prosecutorial theories. We'll have to see what the court says, but it's one that I'm watching because it's in line with a number of similar cases over the last decade or so.
Thank you. And Roman, also my buddy Mark Walsh wants to know if you could talk about the Andy Warhol case briefly.
Yeah, so Andy Warhol, a case that's going to be argued on October 12th. I represent the Andy Warhol Foundation, and it's a copyright dispute over whether Warhol infringed the copyrights of a photographer when he created certain portraits of the singer Prince based on her photograph. And the case is interesting for a number of reasons, but it essentially sort of tees up the question of what the fair use doctrine is and how it should apply. And in particular, the component of the fair use doctrine, which allows a certain amount of copying to be done lawfully when the follow-on work that is being created by the copier or the alleged copier is transformative, whether it's sort of the transformative use factor. And so the court's going to have to grapple with this doctrine, which is a notoriously challenging doctrine. I will just say it's a very interesting case on all sides. There are a lot of briefs and there are a lot of full color pictures of works of visual art on both sides. So it's kind of a fun read, hopefully, for those who are interested in actually getting into the briefing in this case.
And the last question, for which we have about 1 minute, is: are there really important or interesting cert petitions that we're watching? Kimberly, I know you already did a great preview of what was on the docket for the conference yesterday. Maya mentioned one of the Rhode Island abortion case, which we think the court probably won't take, but anybody want to mention a couple of pending cert petitions?
Can I throw in a plug, another personal plug? Is that allowed?
Sure.
We've got
If you're not billing us.
We got a very interesting case called the Buffington. It's a case that implicates really interesting questions about the Chevron doctrine. We represent a veteran who's trying to get benefits that he's owed by the Department of Veterans Affairs. They're essentially denying him certain benefits based on their interpretation of a provision of law, and the Federal Circuit granted Chevron deference to the VA's interpretation. And so we argue sort of two things. Number one is we say that all canons of construction need to be considered before you defer to an agency, including a canon that's known as the pro-veteran canon of construction. And that's what makes the case a very interesting and potentially important case for veterans law, because the pro-veteran canon is really very significant. In addition, though, as a second question presented, we've asked the court to consider whether to overrule Chevron, which obviously would have broader implications if they decide to take that on. The case was sort of rescheduled a number of times in the spring. We don't know why they rescheduled it, but we'll have to see if they're interested in getting into Chevron this term.
Kimberly, you want to mention one cert petition?
Well, I was going to say, kind of traveling along with the case that Ramon just mentioned are these cases about the bump stock ban that the Trump administration put in place after the 2017 mass shooting in Las Vegas, which asked the same Chevron question. And it seemed a little odd to me that they held these cases over in the summertime. I'm not sure what that signals, if it signals they don't know what, if they want to hear it, if they don't know what they're going to do, or if they're waiting on other cases. But those are definitely the petitions that I'm watching most closely.
All right, we are out of time. First of all, let me compliment my colleagues, because I don't think I've ever done one of these where we actually managed to answer all of the questions in the Q&A. So thank you for that Herculean effort. But even more so, thank you for a great discussion, great panel. It's been a pleasure working with all of you. Thanks to the ABA Division for Public Education for doing this with us every year. It's really a wonderful effort, and they're a joy to work with as well. And thanks to the Washington College of Law staff for helping us accomplish all of this. And the video will be available in a few days. Look for the ABA Public Education website. And I think with that, it's a wrap. Thank you, everybody.
Thanks, everyone. Great to be with you all.